finalists, we'll have Ron Walters as a petitioner and Chase Farmer as the respondent. Ron Walters actually won Best Brief in the Baker Cup, and Chase Farmer is actually Best Oralist. So with that, I'll pass it over to Liz.
And my name is Elizabeth Stryker. I'm the Chief Justice of the Moot Court program here at WVU. We would just like to thank the West Virginia Supreme Court of Appeals for their continued support and hearing these cases every year, and also to the Baker family. Thank them for their continued academic support of appellate advocacy. And the case that you'll hear today involves the Fourth Amendment in a criminal case, and it involves an issue about cell phone data point collection and whether the third-party doctrine applies.
All rise and be silent. The Honorable Justices of the Supreme Court of Appeals, Chief Justice Alan H. Lawfrey II presiding. Oyez, oyez, oyez. Silence is now commanded under penalty of fine and imprisonment while the Honorable Justices of the Supreme Court of Appeals now sit. Let all persons having motions to make and appeals to prosecute come forward and shall be heard. God save the state of West Virginia and this honorable court. Please be seated.
For the Baker Cup competition this afternoon, docket number 2017-02, Albert Green versus the United States of America.
Please proceed.
Thank you, Chief Justice, and may it please the court. My name is Ron Walters Jr. I represent the petitioner, Albert Green. Before I begin, I'd like to ask 2 minutes for rebuttal.
Yes.
Would the court like a brief recitation of the facts?
Yes.
The matter before the court today concerns the government's acquisition of Petitioner Green's cell site location information by way of an order, as opposed to a warrant under the Stored Communications Act. This information provided the government with locational information for the previous 6 months before the order was issued. Armed with this information, the government was able to determine that Petitioner Green had traveled to a warehouse in southern Arcadia. Subsequent surveillance and investigation provided the government with enough cause to apply for a warrant. The subsequent search uncovered illegal firearms and drugs. Green was arrested and motioned the district court to suppress all evidence as a result of this government collection of CSLI. The court granted this, and then subsequently the 13th Circuit reversed. Today we ask this court to reverse the 13th Circuit's decision and hold that the government did in fact violate Petitioner Green's Fourth Amendment rights when it acquired his cell site location information, amounting to an invasive, prolonged, and unreasonable search and surveillance of his every move. This is the correct holding today for 3 reasons. First, the Stored Communications Act does not in fact permit the government to get this information. Second, Petitioner Green had a reasonable expectation of privacy in this information, one which society is prepared to recognize, and the third-party doctrine should not act to vitiate that. And finally, on balance, the government's interest here in prolonged tracking is outweighed by society's interest in their privacy in their long-term movements. As to my first point, the Stored Communications Act does not in fact permit the government to obtain this information. This court has long held, under the doctrine of constitutional avoidance, that when a statute can be construed in such a way to avoid a constitutional question, it does so. Here, the Stored Communications Act under 2703 permits the government to obtain cell site location information by way of an order, specifically electronic communications records, Electronic communication, however, defined under 2510, specifically excludes from the definition any tracking devices.
Is there any one specific case upon which you rely that you think is critical to your position?
United States versus Jones, Your Honor, I would say is critical to our position in terms of the reasonable expectation of privacy. Here, for the constitutional doctrine, or constitutional avoidance doctrine, we would point to Ashwander versus TVA, the establishment of the doctrine saying.
Well, in Jones, there was a trespass, am I correct?
Yes, Your Honor, that was.
In this
plurality.
case, there is not.
Correct, Your Honor. The majority of the justice, however, in concurrences, said that an individual does in fact have a reasonable expectation of privacy in the long-term aggregation of their movements. Justice Alito's concurrence is very clear that, in fact, 28 days certainly brings about a constitutional question in that individual's long-term movements. The Stored Communications Act further goes on to define a tracking device as any mechanical or electronic device which permits the tracking of movement.
Well, if Alito's concurring opinion was of such import, then why was that not incorporated in the majority Supreme Court opinion as opposed to standing alone as a concurring opinion? Were it so persuasive?
Yes, Your Honor. Scalia's opinion for the majority, Justice Scalia's opinion for the majority specifically spoke on the trespass approach to Fourth Amendment rights. Justice Alito's took a different tact in that an individual has a reasonable expectation of privacy, and Justice Sotomayor's concurrence went further. So you can see the division in the court, Your Honor. I think it's persuasive, and I think a majority of the justices did in fact hold that position when you combine the two concurrences, Your Honor. With under 3117, it's any electronic device or mechanical device which permits the tracking of movement of a person or subject. Here, a cell phone is in fact a tracking device. The government itself admits as much in the record at 25 and 32 in the officer's testimony, and again in the application of the order. The only thing the government is looking for here is tracking information, location information. As such, the government de facto treats the cell phone not for purposes as electronic communications, i.e. looking for instance, phone numbers dialed or duration, but instead looks to specifically the location information they can get from that. And the government will undoubtedly argue that it's not nearly as precise as GPS, which is a traditional tracking as we saw in Jones. However, this is a fiction. Today, cell site location information is becoming more accurate. In fact, the government requires it to be so. Under the FCC's own regulations, 47 CFR 2018 requires enhanced 911 benchmarks by which a cell phone provider must be able to pinpoint the location of an individual within, as of last year, 100 meters. But every single year, they ratchet it up. Now, this court, in its Fourth Amendment jurisprudence, has said in Kyllo, Justice Scalia's opinion in Kyllo, specifically stating that this court looks to not only what technology is currently available, but also what technology is in development. It's a forward-looking approach. Here, cell site location information is becoming more accurate every single year.
Is this the Cairo and Knott's line of cases that you're talking about?
To a certain extent, yes, Your Honor. And in that, I think it illustrates.
But in there, they held that the tracking was not a search.
Yes, Your Honor. They held in Knott's that an individual doesn't have a reasonable expectation of privacy on public roads. However, in Cairo, the court did make clear.
When was Knott's decided?
Knott's was decided in, I believe it was the 1970s, Your Honor. I don't have that information right in front of me. However, Your Honor, I'm sorry, it's somewhat more recent. Knott's spoke to the fact that you don't have a reasonable expectation of privacy on public roads. Cairo, though, said that individuals in their home, a traditionally protected area, still have a reasonable expectation of privacy in their movements that place them in the home. And this shows the difficulty with the third-party doctrine here. Petitioner Green did, in fact, have a reasonable expectation of privacy in this information, and the third-party doctrine should not act to vitiate that.
Well, how with regard to the third-party doctrine, how does the Fourth Circuit case, United States versus Graham, affect your position?
Well, Your Honor, and all the circuits now are in line with the position that the third-party doctrine applies. So clearly, it doesn't help us that none of the circuits have agreed with our argument that the third-party doctrine hasn't applied. However, this court is in a unique position to abandon the doctrine as it adopted it, and under the Casey factors purported in Casey versus Planned Parenthood of Pennsylvania, an unworkable doctrine can be abandoned by this court.
So you're wanting us to adopt the dissent in Graham?
Yes, Your Honor. Well, I would say, Your Honor, we would either say abandon the doctrine or perhaps even change it to fit a modern society, Your Honor.
So how would you have us, if you have enough time, how would you have us change it in light of Graham's dissent?
Specifically, I think that our position would be that given modern technology and the forces of society on an individual, effectively, it requires an individual who wants to function in modern society to have a cell phone. It's effectively a coercive element. If you don't participate, you can't maintain relationships, you can't conduct business. As such, a balancing test, we feel, would be more appropriate here, with a fulcrum of necessity at the center. On the one side, you would have a situation where an individual is forced or functionally forced into adopting this technology, and on the other, you would have a situation where an individual is adopting it for mere convenience. For instance, social media where they ping their location by choice.
So if we adopt the dissent as Justice Ketchum is suggesting in Graham, you're asking us to overrule the majority opinion?
Yes, Your Honor. And
what does that do to stare decisis?
Well, Your Honor, I think under stare decisis, this court can do so. I don't think that would disrupt necessarily the government's positions. Again, the Stored Communications Act is quite clear that Congress never intended this act to be utilized to track movements of individuals. As such, this falls in line with congressional intent. And clearly, it would obviously change the habits of law enforcement accordingly.
So you'd have us find that no user, like me, by using their cell phone, ever thought or intended to convey their location to somebody else, much less the United States government.
Yes, Your Honor, to the extent that an individual in today's society must obtain a cell phone really to be a functioning member of society, it all stems from that initial coercive effect of society to make it incumbent upon the person to participate. So therefore, we would, the position would be that the third-party doctrine is just, it fails in a digital age, effectively, Your Honor. Now, society passed the Stored Communications Act, or excuse me, Congress passed the Stored Communications Act in 1984. This speaks to society's expectations. At that time, cell phone use was dramatically less than it is today. In fact, there were 681,000 cell phone subscribers at that time. Today, there are well over 330 million. In fact, 97% of individuals under the age of 65 have a cell phone. This, again, speaks to society's expectations that an individual have a cell phone, and individuals don't buy a cell phone with the expectation that the government will, in fact, track their every movement. This information is exceedingly invasive. In fact, 16 states have enacted laws. Now, it only affects their state law enforcement. It does not, in fact, impact the government, federal government, but specifically stating that law enforcement must get a warrant before they obtain this information. The trend is clear that individuals do not want this information divulged to the government without proper care and a probable cause standard.
So would your opinion be, or your suggestion in terms of us writing an opinion, be specifically limited to law enforcement?
Well, Your Honor.
Because, you know, I have a 19-year-old son, and he goes crazy every time I try to track him on my phone, on his phone.
Decidedly, the question would be is whether it's generally available to the public, this information, and constraining it to just law enforcement. For administrative purposes, I think it would be the only time that otherwise that maybe government would get a warrant to do this. But I would say broadly, a warrant should be required for this information, Your Honor. Finally, on balance, society's interests are served here by the government, or excuse me, this court enacting a probable cause standard because society's interest in their long-term aggregated movement outweighs their interest in privacy of that information, outweighs the government's interest. In today's society, again, it's nearly impossible to work, study, or have relationships or operate as a functioning member of society without a cell phone. This court in Riley held that cell phones are doorways as broad as a person's front door of their home. It tells a lot about an individual's life. Today, we respectfully ask this court to hold that the government in fact violated Petitioner Green's Fourth Amendment rights when it acquired his cell site location information without a warrant. And for all the aforementioned reasons, we thank you, Your Honors.
Thank you, Mr. Walters.
Mr. Chief Justice, may it please the court. This case is about cell phone tower records owned by Verizon and lawfully maintained in their normal course of business. My name is Chase Farmer, and I represent the respondent, the United States of America. This court should affirm the 13th Circuit Court of Appeals opinion for two reasons. First, the petitioner does not have a protectable Fourth Amendment interest in Verizon's property. And second, the petitioner does not have a legitimate expectation of privacy in information that he conveyed to a third party, here Verizon. Now, when the 13th Circuit Court of Appeals applied the third-party doctrine to the CSLI records in question, it did so consistent with the intent of Congress, consistent with this court's long-standing jurisprudence, and consistent with every other Circuit Court of Appeals that has ruled on the matter. Indeed, the 4th, 5th, 6th, and 11th Circuits all agree that CSLI records pursuant to a 2703D order should be analyzed under the third-party doctrine.
Well, Mr. Walters seems to think that those cases and those statutes are not in step with technology as we see it today.
Your Honor, respectfully, the suggestion that the Stored Communications Act was passed in, I believe he said 1984, but if I may, I believe it was 1986, is misplaced. The suggestion that it is not compatible with modern technology is misplaced because Congress has amended that act numerous times and additionally has enacted other pieces of legislation that focus specifically on the content of email communications and the NSA's ability to compile mass data. All of these things point to Congress's close attention to the privacy issue at hand.
So you're saying that because of the amendments to this statute that had Congress chosen to take this step, they could have done so with specificity in the statute?
Yes, Your Honor. However, to Mr. Walters' point that the statute itself is contradictory and that constitutional avoidance limits the application of CSLI records is respectfully misplaced because it provides two options. One, to get a court order pursuant to a 2703D order, or it provides an option to get a warrant. However, those two options are available because there are certain circumstances in which a higher Fourth Amendment interest is at stake, such as communication, specific content in the communications of one's cell phone, rather than the CSLI records that identify data points from a cell company's towers. Now, it's important to note that these data points identify cell towers at specific times, not the petitioner's cell phone. In fact, this is distinctly different from the type of GPS real-time technology that this court considered in United States versus Jones. Now, as Your Honor pointed out, that case involved a standard trespassery test because the government surreptitiously broke into the individual's car and attached a GPS
You're speaking
device.
of Jones?
Yes, ma'am. And however, in the concurrence that the petitioner relies upon, drafted by Justice Alito and joined by Justices Breyer, Kagan, and Ginsburg, applied the Katz reasonable expectation of privacy test. However, it's important to note that in that concurrence, Justice Alito identified that the development of modern technology affects what society's expectations of privacy are, and that in fact the legislature perhaps is more suited to identify and establish what that expectation is. And that speaks to the second prong of the Katz test, which states that not only does the individual must possess a subjective expectation of privacy, but it must be one that society is deemed objectively reasonable. Here, in this case, not only has Congress passed this statute, but it's important to note that society by and through Congress has established what is objectively reasonable. Moreover, under the Katz test, it looks to what a hypothetically reasonable person would do in that situation. Now, to be sure, the record in this case is incomplete, but in every other CSLI case that the circuits have identified, every single contract and privacy agreement provided by the cell company identified within its contract that the company would be collecting this type of information and records for a number of legitimate purposes, such as for billing purposes or providing the best care to their customers.
Well, Mr. Farmer, you know, Mr. Walters makes a good argument in terms of he's suggesting a balancing approach in terms of us writing an opinion that says we use a balancing approach for this new test. What's the fallacy of that?
Your Honor, the fallacy of that is that this case is not about lowering the bar from a warrant to a court order. This is a case about raising the bar from a standard subpoena to a court order. Now, under subpoena, the standard is that it must be reasonable, weighing on one hand the legitimate interest in the government against the privacy expectations of the petitioner. Now, there's a number of types of subpoenas that this court has held that actually provide more specific location data than the records in this case, the CSLI records. For example, in the PIN registry case, Smith versus Maryland, one of the initial cases that established the third-party doctrine, because of the nature of the landline, that actually identified when the individual was actually in their home. And in cases, this court has a number of times identified that there is a heightened interest of privacy in one's home. There, because of the landline nature, it actually identified where they were in their home. Now, there's also instances with subpoenas providing surveillance tapes, medical records, hotel lodging registries, airline manifests. All of these records, the CSLI records pursuant to the Secure Communications Act, actually takes a higher standard because it requires a detached magistrate judge to find that there's been specific and articulatable facts that are reasonable to believe that would contribute to the government's investigation and a criminal investigation. And here, the government used this information to aid its investigation, which ultimately led to a warehouse being seized pursuant to a valid warrant after the totality of the evidence brought together that found 200 kilograms of methamphetamine and over 100 illegal firearms. And I would point to Agent Smith's deposition in the record that states that some of those illegal firearms were actually rocket launchers and illegal automatic weapons. Now, going back to my first point, and I think that it's important that it distinguishes from this case from cases where there is a direct search. The information obtained pursuant to the 2703D order came from the cellular telephone network, Verizon, not the individual. This isn't the type of direct evidence or access to information in other cases, such as Riley v. California. Now, in that case, this court held that an individual has a right to privacy in the contents of his cell phone. And as stated, the data points here are distinctly different than the contents of one's communications. And also, the records were obtained, in this case, from a third party, not directly from the individual. And it's important to note that while the petitioner relies upon the suggestion that CSLI records can actually locate a narrower range of location, that actually is not entirely true. It varies between urban areas and rural areas. It can be as wide as 2 to 4 miles, and it can be as narrow as less than half a mile. And while the record doesn't speak specifically to the records in this case, I would point to United States versus Davis, the decision in the 11th Circuit decided in 2014, of which this court denied certiorari, in which the testimony of an expert witness identified that an individual can be making consecutive calls within the confines of his home. One call could go through a tower 1.5 miles away, and another call could go through a completely different tower 1.5 miles away. Moreover, individuals riding in the same car could be on their cell phones at the same time, and their calls would be connected through different cell towers. The mere fact that these records were collected from the third party identifies that the third party doctrine applies. And we ask that this court maintain its longstanding jurisprudence identified under Katz and identified under Smith versus Maryland and United States versus Miller.
So are you suggesting to this court that no new syllabus point needs to be written in this case?
Yes, Your Honor, we are. And that's because the third party doctrine is suited for this type of information being obtained by the government. And I would like to follow back to the second prong of the Katz test is established that what society deems reasonable. Congress has declared such here. Now, of course, this court has the power and the authority to determine what is or is not a Fourth Amendment violation. However, when it's bound by the analysis that requires that it considers what society deems appropriate or appropriate at that time, then it must look to what Congress says. And in fact, every circuit court and a number of other Supreme Court cases, including United States versus Jones, have identified that these types of records, this should be the type of determination that is more suited for Congress because of the advent of technology. And moreover, the cell towers could perhaps go the other way and then have increased capabilities, and less would be required, leading to a less specific location.
So are you suggesting, Mr. Farmer, that if we deviate from what I perceive you are saying is the majority of the courts in the country, we would be legislating from the bench? Is that what you're suggesting?
Yes, Your Honor, I would be saying that. And it is important that issues like this have some deference for the legislature. And here they have, as previously stated, paid close attention to this issue. And I believe Mr. Walters suggested that the cell phone companies are required to keep this type of information. And he referenced a regulation, but I believe what he actually meant to say was the Communications Assistance for Law Enforcement Act, which requires that cell companies have the capability to identify specifically where these cell phones are at a given time, such as the case when an emergency occurs and the individual hangs up on 911 and they need to identify them. However, that is not what CSLI records are. Having that capability through either location services or triangulation from cell towers is distinctly different. The capability and the company storing these records within its normal course of business is two different things and should not be applied here. And to the point of whether or not this information was voluntarily conveyed or conveyed. It's important to note that in Miller and in Smith v. Maryland, the word voluntary was thrown in there because in each of those cases, the third parties, the bank or the telephone company, were acting pursuant to either legislation or direct control over the government, and as such were acting as agents of the government. Here, that is not the case because, as stated, these companies are not required to keep these records. They do so in their normal course of business for legitimate business purposes. If there is no further questions, in conclusion, we ask that this court affirm the 13th Circuit Court of Appeals decision and not abrogate the third-party doctrine in regards to CSLI records.
Thank you, Mr. Farmer. Mr. Walters?
Thank you, Chief Justice. 2 quick points. First, again, Congress has directly spoken to tracking devices and information from tracking devices. Here, the government explicitly states throughout the record that they are treating this as a tracking device. This is not legislating from the bench. This is, in fact, reinforcing the intent of Congress with the Stored Communications Act. And second, this court has long held that, this court has held that individuals, that a cell phone is indispensable to being a member of modern society. In Quinon versus Ontario and Riley versus California, this court has made very clear that it's indispensable to individuals functioning in society. Individuals have a reasonable expectation of privacy, not only in their long-term movements, but also that their cell
Well,
phones...
if what you're saying is true and we would not be legislating from the bench, then why did Congress, if Congress indeed has amended the statute over a period of times, just point blank say it in the statute?
Yes, Your Honor. I can't speak specifically to what Congress does and does not do. However, I would guess that they likely were not aware of the extent to which this was occurring, Your Honor, or the extent to which it reveals about an individual. This is very, very revealing information. It's unlike in Miller or in Smith, where it's just a phone number dialed or a transactional record. This information tells copious amounts of information, paints a broad and vivid mosaic of an individual's life. As such, this is quite an invasive search on the part of the government, and the government, again, has spoken specifically to tracking and said, no, this in fact there must be a warrant to get this information. With that, Your Honors, we respectfully ask this court to reverse the 13th Circuit's decision and hold that the government did in fact violate Petitioner Green's Fourth Amendment rights. Thank you.
Thank you. Your case will be submitted.
All rise. Thank you, thank you, Robert Justice. Leave the room. This court will now recess for possible opinion. court is again in session. Please be seated.
Well, you can tell it took us a while back there, and there's a reason for that. Both of you did a wonderful job, and in fact, you know, we're not supposed to tell deliberations, but somebody made a comment that, you know, sometimes we feel like dogs when we resolve something like this, because we recognize the amount of time that both of you have put into this, and it shows. And quite frankly, it is heartening to me when I see the next generation of lawyers and seeing the job that you did. You both, I know you want me to get there, but we really are serious in that. It was a very, very difficult decision. You both did a wonderful job, and Mr. Farmer, you were successful today, so congratulations to you. And Mr. Walters, we congratulate you most certainly as well. So, see if you can handle it.
Yeah, group shot.
Thank you, Justice. Chief Justice. Yeah, no, I appreciate it.
I've been doing this for 20 years. This is the closest one so far.
We can get a picture of both of you, if you wouldn't mind. She is making me get up here. Except they're not centered now. That's fine. 1, 2, 3. We'll just stand on chairs here. I've had too many pictures with this thing in the way. So.
I thought she was waving at me.
We have a couple with just Mr. Farmer in the center.